What up, everybody? Thank y'all for joining. Give me a second. I'm about to add some things. Give me a second. Give me a second. Give me a second. Hold on, give me a second. Okay. Hold on, give me a second. Give me a second. I gotta get the tip jar. I gotta get the tip jar. Hold on, just give me a second. Hold on, here I come. Here I come. All right, I gotta pin a tip jar at the top. There we go. Tip jar pinned to the top. Tip jar pinned to the top. Do that. Okay. Let's get out of here. What do we do?
Shooter, you shot me in the heart, and I've been dying since we've been apart. Oh, shooter, I don't think I'm gonna make it. See, I'm just as good as dead. I'm good as dead. Whoa, bullseye. Girl, you shot me down to my knees, yeah. Since you took your love from me, and I'm holding on to the hopes that you will return. Although I feel I've lost you forever, I will believe that you still love me. Girl, say you do, say you do, say you do, say you do, say you still love me. Yeah.
Oh, it don't matter, Rolanda.
Shot me in the heart.
Let's get them lights up.
Oh, yeah. And I've been dying since we've been apart. Oh, shooter. I don't think I'm gonna make it. No, and I'm just as good.
What you gon' do now? Hope you're ready, cause I'm really about to put it down. Girl, you know that I will never disrespect you. We have tomorrow, but tonight I wanna spank you. That ass count, gotta make it last now. Start off slow, then I'ma beat it up. Hate on me, but no. Try to say stop when the beat say go. There you go again, that voice is you make your girlfriend come on, come on. You've been waiting patiently, wondering when and where I be. The cousin ruckus in the industry, making this so she can't sleep.
Ooh, these days. Ooh, see, I neglected the fact that your love was precious, and I should have took more better care of it. And now every minute you go, girl, I sit here just dying alone, and I wish that I could have dodged that bullet of you leaving me. Shooter, you shot me in the heart, and I've been dying since we've been apart, yeah. Oh, shooter, no. Oh, I don't think that I'm gonna make it, no. I'm just as good as yeah. Oh, shooter, girl, you shot me in the heart, and I've been dying since we've been apart, yeah. Shooter. See, I just don't think that I'm gonna make it. Without you, babe. I gotta go. I don't wanna go, but I got to.
All right. We have an update in the R. Kelly case. All right. Shout out to everybody that's here. Hey, Fantasia. Hey, everybody that's here. Everybody that's here. What's up? We have an update, an up dizzy. And we have an up dizzy. We have an up dizzy. Hold on, let me go ahead and download this. We have an up dizzy going on for everybody. So do that. So I think everybody that's here. I want to thank all y'all that's here. I want to thank everybody that's here. We had like a little hiatus, but hey, it be that way. It'd be that way. What's this? Okay. Let me get this out the way and +1 and 2. Okay. 4. Okay. Got the 4. All right, let's go. So, let me read it to y'all. The update is, and I gotta hurry up before the storm come. Here it is. Scheduling order as to Robert Sylvester Kelly. Hold on. So people that want to know, that might not know, but scheduling order as to Robert Sylvester Kelly Curcio hearing set for 6/17/2021 at 10 a.m. in courtroom 4G North, ordered by Judge Ann M. Donnelly on 6/11/2021. Then I'm gonna scroll down. Also, it have another letter motion for Curcio hearing as to Robert Sylvester Kelly. It's under seal. I don't think they want anybody in there except for the lawyers. Judge Ann Donnelly is demanding that the government as well as Greenberg and them be there on Thursday. So there's no status conference interview with that. I believe is going to be held to pay in that courtroom. And I think that's why she's doing that. So there's no status line that I can or that anybody else can call in and hear it, nothing like that. None of that. So just giving y'all an update about the Curcio hearing. There's no phone line. I'm looking at it now. I don't see it nowhere. All right. So, second thing. We got that out the way. So, also, if you want to hit the tip jar, it's at the top of the chat. It's pinned to the top of the chat. That's all you got to do is hit that, what's going on? Oh, but that's all you got to do is hit the, link. And once you hit the link, take care of your business from there. Rolanda said, sounds like a closed session to me. Yes. Yes, that's what it sounds like to me, too. All right. Now, let's get some things out the way. Let's go. It's on share screen already? Okay. Let's go there. So what I'm going to do is I'm going to bring this down. I'm going to minimize this. Just a little bit. I'm going to bring this over. Okay. We're going to share screen. All right. Let's go. No game time to play. Let's do it. These are things that has been redacted not redacted, but changed as far as the questionnaire. And Mr. Fernella has redid the questionnaire. So here we go. The Honorable Ann M. Donnelly, United States District Judge, United States District Court, Eastern District of New York, 225 Camden Plaza, East Brooklyn, New York, New York, 11201. United States versus Robert Sylvester Kelly. Oh, so they got both of them as persons now. See what I mean when I say the wordplay? They now got both of them as first persons. United States versus Robertson and Kelly. Dear Judge Donnelly, the government respectfully submits this letter in response to defense counsel's letter filed on June 11, 2021, requesting certain additions and changes to the court's jury questionnaire, docket number 104 and number 105. Specifically, defense counsel requests that a subsection C be added to question 39 as follows. Do you have any personal knowledge about sexually transmitted diseases? The government objects to this request on the basis that it is vague, overly broad, and unnecessarily intrusive, as it may elicit responses regarding the potential juror's medical history. Okay, wait. You don't want to release questions about their medical history, but you want to bring Robert's medical history? Come on, government, stop. Y'all trying to have it every which way. You can only have it one way, and that's the right way. Come on, stop. In addition, as set forth in the government's letter, filed on June 11, 2021, docket number 103, the government respectfully submits that responses to question number 39B will adequately provide the parties and the court with sufficient information regarding the ability of potential jurors to be fair and impartial concerning this topic. The government does not object to defense's counsel proposed change to question 75, which seeks to change use of word punishment to penalty. Respectfully submitted, Mark J. Lesko, acting United States Attorney. All right. So and pretty much the government do not have anything wrong with question 75 because it seeks the change of the word punishment to penalty, which is fair. But what I have a problem with is right here. If the government objects to this request on the basis that it's vague, overly broad, and unnecessarily intrusive, it may elicit responses regarding the potential juror's medical history. In addition, as set forth in the government's letter filed on June 11, 2021, the government respectfully submits that responses to question number 39B will adequately provide the parties and the court with sufficient information regarding the ability of potential jurors to be fair and impartial. So basically, they want people to dig into Robert's past and medical history, but they don't want nobody to question none of the so-called jurors. Okay, let's move right along. Because y'all know how I can get. I can get long-winded with that. I mean, if you're going to be fair, let's be fair, goddaggit. Let's not play along with it. If you're going to be fair, be fair. Letter number 2. United States versus Robertson and Kelly. Dear Judge Donnelly, the government respectfully submits this letter in response to the court's provision of the jury questionnaire. It intends for the use for anonymous jury selection in the above caption case, which incorporates certain additional questions recently added to the proposed jury questionnaire at the defendant's request. Specifically, the government objects to the recent addition of question number 39. A. Have you, a family member or a close friend, ever contracted or been exposed to a sexually transmitted disease? Yes, no. If yes, without listing names, please explain. What's wrong with that? That's perfect. Because if you have never contracted a STD, how can you say this man, how can you rule on this man given a STD if you never even contracted or you don't know nobody that ever contracted a STD? You have to know the origin. You have to know the origin. And the origin is not always the man. Because sometimes women can have STDs and don't even know. I'm just saying. As unduly and unnecessary intrusive. The government respectfully submits that responses to question number 39B on its own will provide the parties and the court with sufficient information regarding the ability of potential jurors to be fair and impartial concerning this topic. In what regard, the government proposes a slight modification to questions 39B to delete without more from the question. So it reads as follows. Is there anything about such an allegation that you believe would affect your ability to serve as a fair and impartial juror? So I believe that was read. Is there anything about such an allegation without more that you believe? Okay. So that's what the government is proposing to take out without more. Okay. The government also respectfully requests that question number 20. Have you ever attended a rock concert? Yes, no, yes. If yes, please state which group or. Then it says question number 39 states the charges in this case involve allegations regarding exposure to one or more sexually transmitted diseases. This is the allegation that question 39B refers to. Then it says performance you saw, where and approximately when. Be excluded or amended. The defendant is not a rock singer. Why ain't he? Rock is just a term. So now the government is trying to make the word rock or rock star or rock singer a prioritized group. No. Robert have rock hits. Plain and simple. I'm a rock star, baby. So he have hits that's in that genre. Okay. So the federal government trying to be petty. As a result, the question is currently phrased is unlikely to result in any useful information. Instead, the government submits that the following question should be added to the section titled Knowledge of the Case and People. Have you ever attended an R. Kelly concert? Yes, no. If yes, please state which concert and approximately when. To the extent a version of question number 20 is included, the government respectfully submits it should refer to concerts more genuinely, and that the court consider the inclusion of a time limitation, i.e., in the past 5 or 10 years, so that potential jurors are not required to list every concert they have been to in their lifetime. Why would they list every concert when it's specifically saying, and then y'all are saying, R. Kelly concert? A rock concert, for somebody who's going to be a juror, I hope they're not dumb enough to put all rock concerts they've been to. We're talking about one person on trial, which is Robert Kelly, not Kid Rock, Bon Jovi, and people like that. I'm just saying. Finally, the government respectfully requests a slight non-substantive modification to question number 71 to clarify the question and correct a typographical error so that it reads as follows. One or more government witnesses may testify that they participated in crimes. The witness may have criminal history and may be testifying pursuant to a grant of immunity from prosecution or an agreement with the government. Use of such witnesses is lawful. As a juror, you will assess the credibility of each witness. Is there any reason why you could not fairly and impartially consider or render a guilty verdict based on the testimony of 1, a witness who is granted immunity from prosecution, or 2, a witness testifying pursuant to an agreement with the government? Yes, no. If yes, please explain. I got a problem with that. And here's my problem with that. The problem that I have with it is, let's go there. Use of such witnesses is lawful. As a juror, you will assess the credibility of each witness. Is there any reason why you could not fairly and impartially consider or render a guilty verdict? Why can't it be a slash there that say guilty or not guilty? You don't want to keep pushing the guilty rhetoric out there, because then they're going to say, okay, this is pretty much a circus, it's a fiasco. They already believe that he's guilty. Let's consider him guilty. Let's not keep saying he's guilty. Let's give them the choice, either guilty or not guilty. So I hope the defense team look at that, because all these guilty, no, guilty or not guilty. And this is one of the questions that Steve Greenberg put in there. So what Steve Greenberg put in there, what makes you think that they're going to give you a guilty plea or a guilty verdict? So why not make it guilty / not guilty, or not guilty / guilty? Let's not say or render a guilty verdict based on the testimony of 1, a witness who was granted immunity from prosecution, or 2, a witness testifying pursuant to an agreement with the government. I believe it need to read this. Is there any reason why you could not fairly and impartially consider or render a guilty or not guilty verdict based on the testimony of 1, a witness who was granted immunity from the prosecution, or 2, a witness testifying pursuant to an agreement with the government? Yes or no? If yes, please explain. I'm going to ask y'all, do y'all agree with that? Because the narrative that they're running with is crazy. So do y'all agree with that? Please say yes or no in the chat. Because I agree with it being guilty or not guilty, not just guilty by itself. I'll wait for your answers while I pull up the other tab. Whew. Let's see what y'all are saying. Nothing. Monica, I totally agree. They know exactly what they're doing. What's up, Dana from Maryland? And what's up, Tyree? They know exactly what they're doing. Yes, it needs to be changed. Exactly. The narrative and agenda is real, so I agree with you, Dana. Thank you so much. Last Z, what's up? Sherry Anderson Hobbs. Hello, DanaJay. Hey, Sherry, how you been? Okay. Let's go there. Honorable Annam Donnelly, United States District Court, Eastern District of New York, 225. Exactly. Yes, I totally agree. They should change that narrative. United States versus Robinson Kelly, criminal docket number 19, 286, S3. Dear Judge Donnelly, counsel for Mr. Kelly respectfully submits this letter in response to the proposed jury questionnaire the court intends to use for anonymous jury selection in the above captioned case. We respectfully propose the following changes. This is coming from the defense counsel. This is coming from Thomas Farinella and Nicole Blank Becker. Question number 39. Add subsection C. Do you have any personal knowledge about sexually transmitted diseases? I think that should be put in there, because people, if you're going to be a juror and if you're going to rule on a case that have or touches on sexually transmitted diseases, I don't think a person ignorant to that case need to be ruling. I think a person that is very knowledgeable needs to be ruling on that. Question 75. Replace the word punishment with penalty, and the government agreed to that. But 39 and the government didn't want 39 to be there. Okay, so we got to see what Miss Donnelly say after that. This is the last questionnaire thing. So these are the updates. Oh no, it's one more. Hold on. Hold that thought. I gotta get that last one for you. Hold on. Let's see what this needs. Okay. Okay, I read that. Read that. Here we go. All right. Here we go. Honorable N.M. Donnelly, dear Judge Donnelly, counsel for Mr. Kelly, respectfully submits this letter in response to the proposed jury questionnaire the court intends to use for anonymous jury selection in the above captioned case. We respectfully propose the following changes. Question 39, add section C, subsection C. Do you have any personal knowledge about sexually transmitted diseases? Question number 75, replace the word punishment with penalty. The government does not oppose this proposed change. Okay, so what I'm seeing now is the government pretty much is like trying to pick and choose what they want to go in there. Excuse me. So that means that the defense team got to do the same. Also, I don't know if it's too late, but if I was the defense team, I will put a motion to eliminate in. I will also put a motion to suppress, a bunch of motions to suppress. I will put the motion to dismiss as well, because a lot of these charges are moot and bullcrap. I think they trying to piggyback off of 2008. They want some type of vindication from Robert, and I believe this is their plan of trying to do whatever they can do to try to get Robert with whatever they want to get him on. So, with that being said, y'all seen the proposed changes. Y'all seen one change not be argued about. It is what it is. For the lay people that's here, if you look at the top of the chat, I pinned my tip job there, and you can tip me whatever you want. $1, $2, $10, $30, $100, $50. It go all the way up to $9,000. But it's not something that's mandatory. It is willingly and willfully. So I want to know. Let's talk about some things. Why do y'all think the government is trying to spearhead a narrative that's not accurate when it comes to Robert Sylvester Kelly? EJ said exactly. It's crazy. Now that Greenberg gone, I sincerely hope and pray that the defense team do work correctly. I agree, EJ. But why do y'all think the federal government is trying to spearhead an agenda and a wordplay when it comes to Robert Sylvester Kelly? To me, they are trying to get them to say he's guilty instead of innocent or guilty. Facts. I agree, Ms. Angela. So I just want to know, because at the end of the day, we now see how the questions are going. I have all of the proposed questions right here. I have all of them right here. Hold on. I have all of the proposed questions right here. All 34 pages of them. I'm just telling you. I stopped on page 7. I will pick up tomorrow morning and do 8 through 20. And then in the evening shift, I'll do 20 through 34. But I have all of them right here. All of the pages are right here. So, cover that handsome guy up. That's what it is. Let's see what you're saying. Their narrative is trying too hard to fit in with the allegations surrounding him, because it seems like ain't working to them to convict Rob. Okay, I agree, because the government has invested so much into this narrative, along with other entities, to have him locked up for so long. They are at the point of no return. Now, J-Rock, when you say the point of no return, they can stop this right now. They can stop this right now. So if the government loses, do you think it will make them or break them in this situation? Or do you think the government need this conviction because of the fact that if they don't, a lot of people will feel confident of taking them to trial and they will lose their conviction rate? That's what I want to know. I meant it ain't working for them because I was typing too fast. Okay, that's cool. I'm thinking that they really need this to be a conviction so that way it will enhance and keep their their conviction rate high. That's what I think. What do you think? I got 13 people that dislike me. You know what? I love y'all so much. I'm going to do this one time for y'all. For everybody that dislike me, I love y'all. But guess what? It ain't phasing me. I thank you for your view. Thank you to 13 people that dislike the case and me talking about the official R. Kelly update. They won't stop it because then they'll look more stupid than what they are. Okay. So you feel as though that they won't stop it because they got to show face. That's why they trying so hard, pretty much. I agree with that. I can go with that. I can go with that. It won't break them, but the other entities like #MeToo and other lawmakers may take a big L for any future bills they may want to introduce based on this case. I totally agree. Some hated Jesus Christ. Haters gonna hate. That's true. That's true. That's true. I totally agree. I totally agree. Oh, wow. Are you seeking a forum to voice your opinions? You take your responses seriously. Yes, I do. Okay, hold on. Hold on. Okay. I got 59 likes. Come on, man. 92 people watching. Let's get them likes up. Get them likes up. Whoever dislike it not for arcade period. Yeah, you're right. You're right. Tried to tip you, but I don't have PayPal. Okay. That's fine. That's fine. Yeah. Yeah, the tip jar is strictly through PayPal. Or you can cash at me, Rolanda, at $ official DanaJay. Official Dana. I'm gonna put my cash up there. Well, it's right there. $ official DanaJay going across the top of the screen. Let them haters be hell motivation. That's facts. Right, Dana, because that's what I'm thinking. Because they invested too much time into trying to get a conviction because it's gonna blow up in their faces as an epic fail to the government as a whole. That's true, EJ. That's true. Who'd I miss? Oh, we got a visitor, Karen J. Hey, hi, Dana in chat. I agree because they are used to people taking plea deals with their scare tactics. That's true. That's true. Karen J, I thought you ain't like it over here. I thought you said I was a liar. And you didn't like it. But I'm glad you stopped in. And what you said is truthful. I told you, a lot of people that went against me, boy, but they gonna have a whole trying but they gonna see in a few. It's at the top. I meant in their faces. Daggone it. Typing too fast. There you go, EJ. They needed just to say they did another brother in. Okay. Certain agree, EJ. Okay. Alright, share, subscribe. Miss Hot Pink, hey. Yo, some petty. So question. Because as the week go along, and we're gonna talk about a lot of things, and I'm gonna pull out some interviews that's gonna happen. So we're gonna talk about a lot of things. I have 91 in the chat right now, right? So what I'm gonna do is this right here. I was gonna wait and do it at another time, but I'm not gonna do that. While I have 91 of you in here, I'm going to premiere the interview. I'm going to premiere the interview. I'm going to premiere the interview that me and Brother Joel did. I'm going to premiere that right now. So that way, people can understand, like, when I engage in interviews, I'm content about what I'm engaging in. So, let me schedule this. What's the day? The 14th? What time is it now? 3:52. Let's schedule it for 4 o'clock. 4 o'clock p.m. Okay. Set a premiere. Schedule it. There we go. All right. So, good. I can See how I can make this happen, y'all. So that way we can all sit and watch this together. Let's see. Let's see. Okay. Let's see. So as a reminder, so everybody that's over here, don't worry about even going over there. This is a pre-recorded interview. Hold on. Hold on. Hold on, forget. Pin that there. Okay. I'm gonna try to set this up. Where's that we can watch it all together. Source. Share screen. Okay. All right. See how I set that up, y'all? Set it up real quick. Got both channels up and running. So now I can talk to y'all like this. Let me see. What time is it? I got 5 minutes. So, question. And before we get to this live closed interview, because I definitely want y'all to hear this. I definitely want y'all to hear this. If y'all to contribute to the channel, Cash App, or hit the tip jar on the pin. There you go, Miss Hot Pink. Hey, Miss Hot Pink. Yeah, my Patreon is there. Pin that. Pin what, Rolanda? Because I have my tip jar pinned at the top. That sounds like from the movie Life, where their sheriff says at least the state of Mississippi got 40 years of cheap labor out the deal. In other words, Ray and Claude. Has Charlemagne been replaced by another guest indefinitely? I heard from a friend he has been. I don't know, J-Rock. I don't know. Spent their lives in prison for nothing. Yep. Keep moving. Free R. Kelly, okay. So the point is what they did in the movie Life. Okay. J-Rock, shoot. If so, good. He needs to go. Hit the tip jar, y'all. If y'all decide to. What up, EJ? What up, EJ? You got it. Okay. What's up, J-Rock? You got it, famo. Okay. Brian Joe. Brian Joe said, I just think they should let him go and put him on probation and house arrest to the point where he can leave out and do his studio with his music and whatever he have to take care of. So I got a question, Brian. And you said you just think they should let him go and put him on probation and house arrest. But that means that he did it. But that means he's guilty of something if he been put on probation or house arrest. We believe that he's going to be exonerated. And we believe over here that, no, he shouldn't be on probation or house arrest because he didn't do it. Let's get these likes up, y'all. Let's definitely get these likes up. 358. Mm-hmm. Let's see. I got 2 waiting over here. Cool. Damn. 16 likes and 7 dislikes already. Come on. Stop. Whew. This is the most hated man in the world. But guess what? I love y'all back. Yeah, get them likes up, y'all. Let's get them likes up. Thank y'all so far. Let's get them likes up. That matches. 92 people, 73 likes, 16 dislikes. That means 89 people to a total. Well, that's about right. I'm just saying until he goes to court and they make the final decision. Facts, Brian Joe. I totally agree with that. I can agree with that. I totally agree with that. Until he goes to court, I think that he should get some type of house arrest and or probation. Because right now he's guilty until found innocent, and that's not the way the Constitution rocks. And the Constitution rocks is you're innocent until found guilty. But as y'all gonna hit, wait till y'all hear this interview. Y'all gonna be like, wow, that's dope. That's dope. I was asking for your Cash App, but I hit it. Okay. Thank you so much, Rolanda. Let's see. Hey, this is the interview. The official interview, y'all. With DanaJay and former lawyer Joe Brodsky. Sit back, relax, take notes. Remember, take notes, everybody. Take notes.
I'm sitting here going, I got a guy on trial for, murder is going to do life without parole if he gets convicted. And I got to worry about these children. This guy, feuding with the guys he's sitting next to. It was insanity.
Okay. Right, definitely. Hold on for a minute, Mr. Joe. Hold on. Because Okay, I got it now. All right, sitting here live with Mr. Joel, the one and only, the internet god. I gotta do it over. Well, here he is, man. You hear him laughing. Here he is, Mr. Joel.
How you doing?
All right, now that we live, questions.
Okay.
Questions. I just got some questions. I just want a dialogue. I want you to be comfortable. You're here. You're here on the DanaJay show, and I got the questions for you.
Go ahead. I'm going to, ask questions. It's the best way because I can, like a lot of stuff. I'm a former lawyer. Once you get us talking, you can't shut us up. We just keep.
and look, and I will just keep it rolling. I will keep it rolling. Question number one. How long have you been practicing in the law field?
I did practice for 37 years.
Okay.
Long time.
Okay.
I have over 100 jury trials. I can't even count how many. Certainly well over 500 bench trials. And it's what I did. I mean, here it's most all of them, but mostly it was 99% of them, Cook County, Illinois.
So it's safe to say that you're not only a veteran, you are a seasoned veteran.
Yeah, I would say so. Very, very few people, there's maybe a handful of people in the state, and outside the public defenders or prosecutor's office, especially private lawyers that have that much trial experience. It's a lot of it's substantial. And that's what I like doing. I like trying cases, so that's how I got it. It was trying cases is a lot. It can be a lot of fun. It really, if you know what you're doing, it can be a lot of fun. But it's also can be quite stressful because you got people's lives on the line.
Right.
Very stressful stuff.
Right. So, question: as a seasoned veteran lawyer, and seeing this R. Kelly case in New York and in Chicago,
right?
Are you any pretty much familiar with the charges that he's being charged with?
Yeah, I mean, I really wasn't following the case very closely until I saw this
fraud,
this debacle starting with Greenberg.
Right.
I was like, holy cow, he's doing the exact same thing. So then I sat down, I went and I looked at the docket sheet and I looked at the charges and because all I had seen up to then was basically what was in the newspaper, online. But I understand, the charges in New York are kind of straight. I mean, they're really bizarre. How come New York is charging him, for example, Eastern District of New York is charging him regarding transactions and things that took place in Chicago? Mostly like for anything to do with the 2008
Exactly.
trial.
Exactly.
I mean, why is that in New York and why is that not in the Northern District of Illinois?
Again, I'm gonna tell you why. I'm gonna tell you why I believe.
Okay.
Simply because if they try that in the Northern District of Illinois, it would be double jeopardy. And because he got acquitted for that already statewide.
Well, yes, that's the thing. Now, there's a problem with double jeopardy between the state court. And by the way, I'm not practicing law anymore, so I'm not really.
No, you ain't practicing law, and you ain't giving no advice.
I'm a former lawyer, so.
And you ain't giving no advice.
I am not giving no advice. I'm a former. I call myself on Twitter, I think, controversial former attorney.
Yes, Georgia girl.
I'm with you.
So
yes.
In any event, but I can give my opinion, and my opinion is that certainly there's a difference between federal and state court and double jeopardy issues. But there's this concept that's called res judicata, collateral estoppel. They're the same things. Collateral estoppel, res judicata. What it means is if something's been established by a court as a fact, you can't contest it or try. It's kind of binding in all courts,
Right.
And you can kind of get around it, but it's difficult and it presents problems. But that would be certainly something that would be very strongly felt in this if you do it in the same case as the acquittal. But you're right, in New York, it's less likely to be as respected. And I think the New York case, though, had something to do with the spreading of the allegedly spreading of a venereal disease.
Yeah, herpes.
Which is a misdemeanor, and but they used that to kind of hook in the federal jurisdiction, the wire fraud jurisdiction,
right?
And that type of thing. And it seems like almost kind of, they really went and stretched to make a case in New York.
Right.
Why? God only knows. But they really, it seems like the main event would have been the charge in the Northern District of Illinois, and the one in the new charges in Cook County.
Exactly.
So why is the the weakest case going first?
And
yeah,
but see, and that's what I was trying to tell everybody, but that follows me, in the fact that the New York case sound complicated, but it's actually the weakest case. And the thing is the federal government knew that. That's why they sent somebody who proclaims to be Robert's friend to come and do all this other stuff, so that way all the other stuff is going to fall off. But they're hoping to get him on the RICO charges pertaining to his friend having one of the accusers / victims car blown up, and then trying to get him on the phone and stuff like that.
Yeah, and that's what's strange, because the RICO. I mean, RICO is a very complex statute that's meant to get the mobsters, like the John Gottis of the world, and what they're accusing Mr. Kelly of is really just a simple, I mean, when you come down to it, it's a basic statutory rape case. I mean, that's basically it.
Right.
And they seem to have taken a statutory rape case and kind of blown it into this big, complex federal case that just out of proportion to what it really is. But be what it may. I mean, he's got the charges and they're keeping him in jail. So you can't just say it's a farce.
So let me ask you this. Mr. Joe. I'm glad you said that, because a writ of corpus habeas,
yeah,
that will be able to really overrule that, for that RICO ruling, and at least give him home detention, right?
Well, they tried. I saw it when I looked at the docket, and I want to correct something.
No, but that came from somebody else. That ain't come from. Yeah. Greenberg struck that down.
I saw something about that, but I forgot where I'd seen it. Somebody had filed a habeas petition, and then it got knocked down. And the habeas, what the habeas corpus is well, they can be used for a lot of things, but what you see them used for is a guy who's been convicted in state court, and he's going to the appeals court, and they've confirmed it. And then he goes to the state Supreme Court, and they affirm it. But his federal constitutional rights are violated by the courts, and the state courts are just not doing anything about it. So you can go to federal court on what's called a writ of habeas corpus,
right,
and challenge their right to detain you because the detention violates your federal rights. The bond issue is really difficult. At this point, it really doesn't matter much. You're only 2 months from trial. But it's a difficult issue. But they basically Kelly wasn't. The government just wasn't going to let him out. That's just bottom line. They're just not going to let him out. He was one of those. You look at it. They let Avenatti out, even though he was a serial scammer and thief.
They let Josh Duggar out. Now that's what kills me.
Yeah, they let guys like what was his name? The guy that scammed $50 billion. In New York. What's his name? Bernie Madoff.
Yep.
They let him in home detention.
But you heard about the Josh Duggar case?
That name sounds familiar.
That's the one that raped his 2 sisters and raped his 2 daughters.
Oh yeah, and they let him out on bond.
Yeah, they got him out on bond, and they said that he was in For they said that he was a flight risk. And he turned around and said, I'm too famous to be a flight risk. But wait a minute.
Oh, yeah, I know what you're talking about.
If you're too famous to be a flight risk, then what about Robert?
I mean, look, and then that's, you know, and that's what's, you know, I mean, really, you know, Rob, you could make arrangements to keep a guy in home detention if you want to.
Right.
But they just weren't going to do it. They were going to keep him in jail. And then I look at all these other people that got out, and I look at Robert, why did he get out? And I got to tell you, there's certainly not, at least from an outsider point of just looking at it, you know, in the macro from the outside, there seems to be a bit of racism there. You know,
I say that too.
You know, I mean, you know, you got the big, you know, I mean, you know, you got these middle-aged and old white guys, and they get to go sit in their apartments while it's going on, but the big, powerful black guy, you know, he's scary. We're going to keep him in jail. Yeah, that's what I think is yes. Yeah, I think it's kind of obvious. I think, right. but yeah, I mean, that seems to be the message that they're sending.
Right, because I sent I sent Greenberg, but I told him to fill it out and just submit it, and it was a declaration under color of law.
But you know, they're not gonna. You know, one judge is gonna overrule another judge. But look, you know, the bottom line is, look, he's got a trial coming up in a couple of months, and right now, you know, there should be real serious. You know, they've blown a lot of deadlines and wasted a lot of time and opportunities to do things, and they got 2 months to do it. And you know, I don't know if they even can do a lot of these things they need to do in this 2 months. But they need to get to work. And apparently, you know, obviously, you know, Greenberg wasn't doing anything, just like in the Peterson habeas.
Right.
So the lawyer Tom and Nicole, you know, they need this is a diversion. This needs to be resolved.
They're great people.
Fast.
They're great people.
They seem like very competent people. They seem very smart people, and they seem to be dedicated. So just wanting to get the job done and done right, and they need to, you know, a case needs to get ready for trial.
Right.
You know, it's you know, so you know, this diversion needs to be put over with. You know.
Right.
It's funny. You know, apparently. And this is Greenberg's forte. I mean, this is what he does. You know, I'm the best. You know, he's trying to come up with something that the argument is going to say, Judge, I want you to tell Mr. Kelly that I'm the much superior lawyer, and I'm the one that really knows what's going on, and I have all the experience, and he should go with me, and he shouldn't trust these other people who aren't as good as I am. You know, qualifications and experience and all the other stuff. And that's what he wants, and just kind of like scare, Mr. Kelly into you know, taking him and getting rid of these other two who are not letting.
Well, I don't think that's going to happen.
No, here's why. And the judge, I think, is smart enough to know this. If they even tell him, you know, you got 5 licensed lawyers.
Right.
You know, okay. If the judge gets into trying to tell the client or tell the defendant that one lawyer is better than another, more experienced, better, whatever, better qualifications or whatever than the other, that's reversible error. Period. End of story. The case is, you know, if there's a conviction, that conviction gets tossed out.
Right.
You cannot even bring that up. And the judge, I'm sure, knows that. So I think that Grimmer is going to try to do that on Thursday, but I think that the judge is going to shut him down pretty damn fast. You know, and all these things about, you know, problems that Tom may have had in the past, you know, she may ask him if he has any questions or any concerns. And if he says no, it's the way I think it'll be over in just a few. Hopefully, it'll be over just in a few seconds. But
yeah, but what did that have to do with what's going on now? Whatever Tom had going on back then, that's that man's business. That's not for the world to know.
Yeah, I kind of feel bad. That's why I really feel bad. That's why I try to encouraging people to, tell them that there's whatever different groups are, just that they should, try to, tell them that they have people supporting them and helping them, behind them, because it's really, it's stressful when you're out there, when these type of things come out and people attack you in public with. Everybody's got flaws. Everybody's got shit in their past.
Right.
Right? And, it's, but, he's a very competent lawyer. I mean, he has a lot of experience in state court cases, criminal cases, a lot. And, now there's Greenberg trying to say, oh, well, I'm a federal, criminal lawyer. Hey,
is he?
What type of federal case? Well, think about it though. Which is more experienced? Which is the tougher, more complex? Okay, you don't see murder and rape and armed robbery cases, real serious cases get tried in federal court. Federal courts are like mail fraud and white collar crime, 99% of it. A couple of terrorism cases here and there, but they're real, a couple of mob cases, but those are very, very few and far between. Mostly they're just con men and scam artists and stock fraud, stuff like that. The real serious crimes are in state court. That's where you get your murders and your serial killers and your really serious crimes.
Right.
So a guy that's practicing criminal law in state court is really going to have to deal with much more serious, much more, where there's a lot more at stake and actually really more complex, from an evidentiary point of view, than a guy in federal court. So I think that, he's making, it's just the opposite of what Greenberg's saying. A guy that's more experienced in state court than federal court is a guy I think you really want they're defending you, because he knows what is, when there's a lot at stake, he knows what to do. Whereas a federal guy is, going to be, 99 or 95% of cases in federal court are just pleas.
Right. Right.
So but
I'm gonna say this:
trials.
I watched Greenberg get handled in state court, actually in child support court. I mean, I was looking like, yo, are you gonna say something? And it got to the point where he got so frustrated that he just started swinging in the chair and chewing on the pen. And I'm like, bro, there's certain things you can say. And I'm sitting in the back, like, saying to myself, like, one of the questions when the judge was like, Mr. Kelly, we want Mr. Kelly and to hand over his correct address. Wait a minute. Greenberg could have actually refuted that, but he was like, Your Honor, okay. Your Honor, okay. No, you in court. Court is a battleground. And you got to show why your client shouldn't do what the state or the federal government want them to do.
Well, it's look, we had a problem with him at the beginning of the previous trial where we had told him that, okay, you're going to object, if the state's asking questions, their witnesses, and there's a problem. Mm-hmm. You're the one that makes the objection. Usually they designate, if there's more than one lawyer, they designate a guy to actually make the objections.
Okay.
So all of a sudden, we're going along, boom, 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 and then, the state would ask the question that was improper, and we're all sitting there going, object. And he wouldn't object. And then, it would happen again, and a few more times, and finally, we got 4 lawyers standing behind them saying, Steve, fucking object! And he wouldn't object. So, like, after the first day, we had to take that job away from him. We're like, what the fuck is wrong with you? Why aren't you objecting? And, I think that, my opinion is that he was more interested in going out into the media room and talking to the reporters and trying to arrange interviews than he was in actually preparing for that day's court.
Let me ask you this. I'm glad you said that. Because I was told in New York Federal, and when Robert went last time, and everybody was able to go in and before COVID, I was told that Greenberg went to go eat lunch with Gloria Allred. And Gloria Allred is a prosecuting
Yeah, I know Gloria.
Right.
Yeah, but she's a Hollywood lawyer, and her daughter has those all those those shows, those
right.
TV shows,
right?
So once again, I mean that's he's trying. He wants to he wants to be on TV. He wants to be his face in the news and his face in the media, and
but she's the enemy, and you can't go in. You know what I mean?
I don't know if you call her the enemy, but look at what you got a certain amount of time. You're in the middle of a hearing. We used to like during the piercing. Okay, I had arranged during that trial. I remember we had an 8-week pre-trial evidentiary hearing, and then the trial itself was 8 weeks. So that's a long. That's a lot of. That's 8 weeks, a long way. For 2 months to go for trial. Mm-hmm. So I had arranged and all. We rented out a little office right across the street from the courthouse because there was. It was Will County, which is a county over from where Cook is, and and then I had arranged for lunch to be delivered every day, so that we could all go from court. We have an hour and a half break. We can all sit there and discuss what's going on and go over things, prepare for the afternoon. So you don't have to go out and everybody's not going to different places to get lunch and running around. We'd all come back at a place to go, a place to sit. Lunch was there, and we'd eat and prepare and talk about what was going to happen in the afternoon and plan ahead. And the one thing that always happened, almost on a daily basis, was we all get there and start, opening our lunches and start talking, and everybody looked around, well, where's Steve? Because he never went. Wow. He never came. Because he was he was downstairs talking to the court TV person or. The Tribune reporter, or he'd be in the media room having lunch with the media people. Just wasn't seem to be interested in actually trying the case. He was interested in the publicity that the case generated.
It's definitely a pattern of Steve doing that. It's definitely a pattern.
That's kind of why I came forward. That's why I started tweeting this stuff, because you're 100% right. There was a pattern here. He wanted to do what he did to Peterson, which was use him as a vehicle to get his name in the paper. And, and we used to call him name in the paper, name in the media.
Right.
And that's what I, felt was Cali. And then when I looked at the docket, I'm
about to go there.
Oh my God.
But I'm about to go there. I'm just, like I say, me and you on the same page, Joe, because I'm about to ask you, man, look, you're a seasoned a lawyer.
Former attorney.
Okay, you're a seasoned former attorney. Yeah, great. Right. Let's put it like that. You're a seasoned former attorney, right? Mm-hmm. So let me ask you this. If you was the lead on this case, right? In 2 years, how many filings would you have put in there?
Jesus. It's funny you asked that question because on my computer I pulled up the old Peterson file. Mm-hmm. And was looking at the motions we had filed. And literally, remember, we had 8 weeks of evidentiary pre-trial hearings before we did trial. About almost a year before the trial started.
Right.
But literally, we must have filed between 75 and 100 pre-trial motions challenging different parts of evidence, different pieces of evidence.
And that's just pre-trial.
Right. That motions, right up there, motions to eliminate, motions to suppress, motions to exclude evidence, motions to try to narrow the what type of evidence could be admitted.
Right.
They wanted to try to introduce a demonstrative, like a model of what the bathroom that Kathy Savio died in, what it would look like, and we objected to that model, objected to it, and there had to be a hearing on that. I mean, all these different things, challenging basically every single piece of evidence. They wanted to try to put in a bullet that was allegedly left in front of a witness's house shortly after Kathy was dead,
right.
And and challenge that bullet. You say, oh yeah? Let's see the chain of custody on where that bullet's been. How do we know that this is the bullet that actually was left there, if there was a bullet left there? So we would challenge every single piece of evidence. And did was, and then every witness that was going to testify, we would file motions to try to narrow what they could testify to. Saying, okay, this witness saw what. We don't want the witness straying off, into speculation or saying something that we didn't expect when they finally took the stand. So we brought motions to kind of try to narrow what they were going to say and what was allowed and what wasn't.
So,
that's what pretrial litigation is all about. And I mean, that's what you got in a serious criminal case. That's what needs to be done.
So,
and it wasn't. It hasn't been done in this
at all.
Kelly's case. Neither. Look, not at all. No, the only thing I did look. I looked again today, and there's this thing called Rule 35, Section 3500 evidence. That's what they call, which are statements or grand jury transcripts of witnesses, and statements taken from that the government generally, usually when you 2 years ago, there should have been a motion. Usually, they would file a motion at the beginning of the case asking for an early disclosure of that evidence.
Right. Because
the government really doesn't have to give it to you, technically, not even until after the witness testifies. But they, generally don't give it to you for 60 days before.
Wow.
Or even less, 30 days before. But you ask for it earlier, and the judges will generally, tell them to give it to you earlier so you can prepare these motions and eliminate motions to narrow the focus or the scope of the testimony or exclude them from testifying to certain things. And but in this case, I said that I didn't see such a motion. Actually, and there wasn't.
Right.
What there was the judge had ordered. I noticed it was kind of hidden in the language in the docket sheet, but she ordered the disclosure of by on her own in late February of 2021. So February. So they did. There was a question about whether or not they could disclose the names of the people, but that was resolved because I think I haven't, from the news reports and the order. It seems like the judge, said that put a protective order on the names, but did give the names to the lawyers.
Right.
And so they've had this since late February. So when I said that they hadn't got all the 3,500 material, I think they got most of it. And they had there was some issues with the names, so they didn't get a full 100% disclosure, but they got at least 90% of it.
But I was shocked to see there's no Brady material.
Well, Brady material is different, but on this 3,500 material, but then I said to myself, okay, I was wrong about that. They got it in February, or they got it, 65, 60, 70 days ago.
Okay.
All right. Where are the fucking motions? Where are the motions eliminate to exclude witnesses, to suppress witnesses, to narrow witnesses' testimony?
Where are they?
Sometimes you get a statement where a witness says something in the grand jury that they say something else later on.
Thank you.
We bring a motion to say, Judge, they said two different things.
Mm-hmm.
Either prevent them from testifying at all because they're unreliable, or they got to pick a story. So which one is it? And because we just can't sit there and guess which one. So where are these motions? These motions should have all been filed. So the fact that they got something that they didn't, when I was saying they didn't get it, that was bad enough. But now we know they got it 2.5 months ago, and they still haven't done anything.
No motions. And
what the hell's going on?
And see, because Greenberg is the one that want to file all the motions.
Yeah, I understand. That's right.
Greenberg don't want nobody else filing motions. He don't want nobody doing nothing. Everything got to go through him.
Which to me is like, okay, fine, but at least file the motions.
Now I do know a couple of the lawyers then gave him motions of limine. And
yeah, motions of limine, right.
I'm gonna go here for the people in the back. Could you explain what the motion of limine is?
Motion in limine, it's a Latin term in limine, but basically it means before. Basically, it translates motion before trial, or motion before hearing. But what it really is don't worry about the Latin name. What it means is it's a motion for a ruling on evidence to be admitted at trial. So let's suppose it can work both ways. Let's suppose that you have a witness who was given 3 different stories to 3 different people, and and just can't keep the story straight. Okay. And rather than you can do 2 things. That witness can either testify, and then as the cross-examination, you tell the jury, you show, hey, you've given other statements, you're not reliable, so the jury should listen to you, which is always kind of the. But the other thing you can do is bring a motion to limit and say, so this person is unreliable, they should not be allowed to testify, because our job is not to confuse the jury with 10 different stories.
Right.
That's not fair. I mean, we don't want confused juries. That's not the job. So and then she'd bring a motion like that. That would be one example. Another example would be a guy you see in the statement. He talks about 5 different issues, and 2 of them are hearsay. So you bring a motion to eliminate and say, Judge,
hello,
he can testify to 1, 2, and 3, but we want you to enter an order now in advance that he can't testify to 4 and 5 because they're hearsay.
Yeah.
And the judge enters an order that he can't testify to the hearsay issues. And then, if he does, even though we ordered him not to, that's great because you can have a mistrial.
Right.
And, okay. So you can do it, and then there's another reason to do those things.
Okay.
Because usually there's the witness who you're going to have the issue, or you're talking about if it's regarding an issue or regarding evidence.
Mm-hmm.
Somebody they have an evidence. There's a hearing where there's somebody testifies at a pretrial hearing, and now you have the transcript of their testimony under oath. So if they get up on the stand at trial and say something different, then you can pull up their transcript and say, hey. Because you're not allowed to do discovery depositions in criminal cases like here in civil cases. So you do these motions instead, motions to suppress, motions to eliminate. So you can basically, get what's basically a deposition. So if the witness testifies to something else at trial, you got him basically saying 2 different things under oath.
Right.
And the argument is the jury then shouldn't believe anything they say.
Right, and also they can be charged for that too, right?
Well, yeah, I mean, they generally are, very, very rarely, but the point, if the guy's acquitted, that's the goal. Or to raise a reasonable doubt.
Okay, so motion to suppress.
Yeah, motion to suppress a statement. Now, that means the suppression is typically a guy gives a statement. They want to use anything that Mr. Kelly said, like in that stupid interview we gave with Gail King. Okay.
Now, wait a minute, wait. And before you go any further, I gotta say this, because this killed me. Greenberg said that he wasn't at that interview, right?
That's what I've heard he said.
I have photos of him being at that interview.
I believe if you watch the tape really closely, you can see his head.
Exactly.
But I can't say that for sure. I mean, I haven't done a forensic analysis of the tape and slowed it down and taken a frame and enlarged it or anything to see if it is him. But I've certainly heard people say that.
I'm going to put some some photos up on Twitter tonight.
Okay.
And I'm just going to ask, is this Greenberg or not?
I'll tell you. I mean, I'd be happy. I like to look at him. But,
definitely. But go ahead and finish with that. Go ahead.
Yeah, but suppose that by the way, if he wasn't there, that would have been out of character. I mean, you couldn't keep him. When we had a problem keeping him off the camera, not
Right.
So, but anything's possible. So anyway, the government wants to use some of that stuff against him. All right. So you can bring a motion. You want to suppress that. You don't want that to come in. You want to suppress the statement. Okay. There's lots of different reasons you can do it. It's out of context. It's unreliable. Just a number of different reasons.
Right.
And then if you have a statement by a witness, right? You can bring a motion to suppress that witness for certain reasons. Let's suppose you're an undisclosed government agent. They've been paid. All right. So there's and they weren't properly disclosed or properly. That whole process wasn't done properly. You can ask that their testimony be suppressed. Where are these motions? You're talking about hate to say it, if he's convicted, he could die. He could be the rest of his life in prison.
Right.
So this is not a game.
Right. So question, but I have a statement and a question. So it's like a combined situation. All right. For the so-called accusers / victims that have been paid, whether it was instructed by Robert Kelly or wasn't instructed by Robert Kelly, they have been paid. And the way the court of law is, when there's a remedy that has been met, you can't come back and sue criminally once you already got a remedy for that situation.
Oh, you're talking about people that sign non-disclosure agreements?
Yes.
Yeah.
Yes. So what I'm saying is, can they do a motion to dismiss for all those that signed one?
Well, certainly an issue. Now, generally speaking, you can't, a person, you can't buy your way out of criminal liability. So if you commit a crime, you just can't pay off all the witnesses and victims' family. You kill somebody, you can't just pay off the witnesses and victims' family and then, get them to sign papers and get away with the murder, right? But that being said, in a case like Kelly's, where there's a guy, a very famous and very wealthy man, who a lot of people will sue just for monetary reasons, not because they were really harmed or anything happened, but because they can make a buck. Rich people can be targets, for that type of scam. So a lot of times what they'll do is rather than spend hundreds of thousands of dollars fighting it, they'll pay them off really cheap and get an NDA, get a non-disclosure, and a release and everything. Okay, I mean, that's just cost of doing business in the entertainment industry.
Right.
So what you do is you would bring a motion and say, like I said, this is not legal advice,
right.
Please.
Right.
This is just, my musings and my opinion is from...
It's your years of expertise analysis.
Years of experience, right, yeah. I'm not telling... Kelly's lawyers what to do or anything.
No, you good.
But what I'm saying is that you can bring a motion and say, Judge, we have somebody here who signed a document that said that they're accepting money, and that they're agreeing that that the government, that what those releases generally say is that it's a contested fact and there's no admission of guilt. And they're agreeing that, that there's a contested fact about whether or not Mr. Kelly did that. So we want either that witness to be excluded, or we want the jury to be informed that that witness has agreed in exchange for money that Mr. Kelly's, that allegations against Mr. Kelly may or may not be true. The allegations they made.
Well, if that's the case...
We want you to instruct the jury that makes that witness's testimony less credible because of this. And you can get sometimes an instruction like that. And you can imagine a judge telling the jury, hey, this witness, there's problems with this witness. They might have an ulterior motive. That obviously is something that the defense would really want. So you want to bring motions like that on every single one of those witnesses, and you want to try to, either very narrow their testimony, or restrict it, or try to get instruction on it, or try to get them, get orders, that basically say that when they're asked this question, they can't try to avoid answering the question, yeah, I took money, in order to say that it didn't happen. But it did, but now I'm saying it did happen. They can't try to worm their way out of that.
Right.
And you want to bring motions to lock them in on their test, on what they're going to say. Each and every one, and not to do that. I mean, and this is what bothers me. This is why when I really decided to, get everything going. I got more stuff that's going to be coming out. Trust me. When I started to put stuff out, showing what Greenberg really is, because I'm looking at this thing going, man, this guy's got 60 days left to do basically 2 years worth of work, and I mean, this is a travesty. Look, I've said this before. I don't know if Mr. Kelly is guilty. I don't know if he's innocent. I wasn't there. I don't know what happened in those houses. I don't know the relationship between the parties. I just know what I read in the paper, and
Right.
we all know you can't believe, if you believe 1% of what you read in the paper, it's 1% too much.
You're done.
Yeah. So, I don't believe you. So, I don't know. All I do know is that everybody should be entitled to a fair trial with a lawyer at least doing their job properly, and a jury who won't convict them unless they're proven guilty beyond a reasonable doubt. That I believe. Everybody. I don't care who they are.
Facts.
I don't believe what they're accused of. This is a basic thing, because if the government can put you in jail without that, then we're really not living in a free country anymore.
Right.
So and then I saw that. This guy who's basically, he's a great artist and a genius in music, but functionally illiterate. So it's very difficult for him to talk to his lawyers and go over paperwork. And he's in a jail 1,000 miles away from the lawyers who are actually doing the paperwork. I don't know, how the hell is he going to get a fair trial?
Right, and
like this.
Right, and then after that,
it's impossible.
Right, and then it kills me because Greenberg is less than 15 yards away.
Yeah, his office, he's in the Monadnock building on 53 West Jackson, and then you go out the back door on Van Buren Street, and you're right there at the Metropolitan Correctional Center. He's right across the street, yeah. And I used to be in that building 20 years ago. It's a great building. It was built by Glenn Wright, and it's...
oh, man.
Yeah, it's still, to this day, the tallest load-bearing structure in the world. In other words, there are in the wall, it's all brick. There are no steel girders. It's all brick.
Wow.
It's all masonry. And
so it's no beams or nothing in there?
Nothing. No beams. So at the base of the building, the walls are like, 15, 20 feet thick, because they support the whole structure. It's like... it's really something. It's an amazing piece of engineering. But in any event, it's a really great building. So when I was in that building, it still had elevator operators. Guys that would take you up and down.
Right.
All day, that was their job.
8th floor.
It was wild. Yeah, you don't see that anymore. But that was a good unit. They had a good unit. But anyway.
Right. So question. I got another question for you. How did you feel when you was working with Greenberg on the Drew Peterson case?
I mean, it was initially, when he was, we gave him his assignments, we worked on one appeal that we were dealing with, and he seemed to be, doing his work on that, and we got the appellate brief filed. It didn't really see, but, I could tell things didn't start going south. I didn't start seeing problems until about a month before the trial, when he started complaining that his wife had left him, which she did right around that point in time. And then, he just wasn't, he wasn't preparing for his, he kept wanting the best witnesses to cross-examine. He said, I want to cross-examine this person, star witness, really tough witnesses. But he wasn't preparing. And if he didn't get all the witnesses he wanted, he'd get upset. And then he started...
And that's what's going on now.
Yeah, that's what I'm saying. He's doing the same friggin' playbook.
Mm-hmm.
That's
what's going on now.
Yeah, he's running the same playbook to try to take over the case, just like he did in Peterson, so that, he could use Kelly as a vehicle to put his name in it, which is exactly what he did with Drew Peterson. I put out today the docket sheet in Drew's habeas corpus case.
I got that.
And look at that. Now, it's been over 2 years. Not one thing filed. He filed the complaint, and that's it. In 2 years, it's, and Drew, Peterson, I'm not saying that Peterson was convicted, of all these crimes. It was not because there wasn't any evidence. I'm not trying to paint Drew Peterson as some sort of victim. He certainly is not. he got a fair trial. He got 2 fair trials, actually.
So is he still in jail or is he out of jail?
But he's sitting there. Yeah, he's going to die in jail. He's never getting out.
Drew Peterson?
Yeah, he's never getting out. But the point is that he's sitting there locked in jail thinking that at least, somebody's trying to do something for him with this habeas petition, and nothing's getting done. Not a goddamn, nothing. I've never seen anything like it, where you have a case just sit with nothing happen for 2 years, and the guy's sitting in prison, and you're filing a pleading that says that this guy's fundamental constitutional rights were violated. Wow. And you just file the paper and do nothing about, give a couple of newspaper articles blaming everybody else for his conviction, and you do nothing for 2 years? What the hell is that? So that's kind of and the reason he did that was because the only thing he wanted to get everybody out in Peterson and be in the case and have himself in control of the case, so he could use it to give interviews and to get his name in the paper and to say, yeah, I represent this big name, high profile criminal, and I'm special and great and wonderful, and look at me, wow. That's his goal. That was all, and that's what I think. My opinion, right? Because I can't, cut his head open and look inside to what's going on in there. But my opinion, it looks like he wants to do the same thing with Kelly because he's acting in the exact same way.
Because see, I'm gonna tell you, and what actually got me thinking that as well. When the Derek Chauvin case was going on, he went on court TV to give analysis about the case. But wait a minute, why would you give analysis about a Derek Chauvin case when your client don't have motions to eliminate, motions to suppress, or motions to dismiss? So how can you give analysis about anything?
Oh yeah. By the way, there's a really good motion to dismiss that I think, like I said, not legal advice, just my own pleading, my own kind of like thinking on it. I think that there's a really good motion to dismiss that can be filed in this case in New York, challenging the jurisdiction of the New York courts.
Exactly. You know what? But I'm already on it. I sent it up to.
They're good lawyers, and
right.
They're good. That's why I hopefully, with everybody showing love and support for Tom and Nicole, and this will be over with. Thursday, there won't be much damage done to the case.
Right.
And they'll be able to file these motions because, especially when you challenge a jurisdiction, a court, can't ignore that. You can challenge if you've got a solid jurisdictional challenge. It's got to kind of stop everything and look.
Right.
Because and so I think they'll do a good job. They're sharp people. And they'll do the right thing, But I just kind of keep wondering why that wasn't done before. Because if I can see it,
because Greenberg ain't allow it.
Well, there you go. And then how do you not allow somebody to do that?
And that's part of the reasons why Doug chose to take a step back because him and because him and Greenberg kept clashing, and Doug said that he didn't want to hurt the case, but. I made a call. I didn't speak to him yet, but I'm vouching for Doug to come back and rock with Tom and Nicole.
Yeah. 3 people is enough. Good amount for this case.
Mm-hmm.
It's not that Tom is anywhere near not sufficient enough. He's good. He's more. He could do the job. With file a motion. But I mean, what I don't understand is why. Well, I do understand why, but it's crazy not when we have other lawyers who want to file legitimate motions, not to stop them from filing it. It's absolutely insane.
Crazy.
I mean, when I used to do it, when we had one time 5 lawyers, and guys, they would say, Joe, we think I would go with this issue, and I go, great, write it up, file it. The next court day we're going to be there, such a date, set it up for that date. Let's get it going, and then they would do it. And because they're professional, I let them.
Right.
I wasn't trying to micromanage them. They asked me, and if it was legitimate, thing, I give. Well, who am I? I'm not going to, that say that I'm going to be one with enough intelligence to decide. They got a good case. They got a good motion. They got a good reason. Hey, man, I mean, who knows? Maybe that's the one that's going to catch the judge's attention and get the case kicked out. Why should I stop it? It makes no sense.
Right. So, Joe, let me ask you this:
Mm-hmm.
if you had to sit back and think about any regrets from working with any of the lawyers on the Drew Peterson case, what will be your number one regret?
I mean, clearly, agreeing to let Greenberg come on was the biggest mistake, because what he was basically doing is sabotaging the case. While during the trial, I mean, he was not prepared for witnesses. He would be insistent of, making scenes that he wants to do this witness, but he wasn't prepared to do it just because he could be there and look important. We had to stop him from going on TV because he was going on court TV.
I got those pictures too.
Yeah, and it was crazy, When you don't think that the prosecution can listen in and find out what we got planned for later that day.
Fact.
It was insane. So, that was a big problem. But look.
And
Mr. Kelly seems to be very solidly, he understands, I think, how he's kind of been screwed over, and I don't think he's very happy. Probably, I don't know, but I'm assuming he's not very happy with it. And I think he realizes that he needs to, kick Greenberg to the side if he's to have any chance at getting a fair trial.
Well, you know what I'm actually thinking as well? I'm thinking Greenberg milked this as much as he can or could, and now that he's down to the wire and he don't have half of the stuff that he lied to Robert and said he had ready, I think that he went in and said, well, Robert, take a plea. And Robert's like, man, you don't get the hell out of my face. I'm fighting this.
I don't know. I don't want me to.
Yeah, that's just my opinion. That's my opinion.
I got news for you. If he got a good enough offer. but
What you say? If he had a good enough offer, what?
If he got good enough, that includes all the cases. You don't want to. You got a case in Chicago, case. But if there was a general settlement that was a reasonable thing. I mean, but look at. That's a.
What would be a general? What would be a good offer to you in this type of case?
God, that's something that gives him a life. How old is he now?
54.
Then get him out before 60. I mean, he's got 2 years in.
So anything to get him out and before 60, it'd be a good offer.
I think so. I mean, but I don't got to do the time. He's the one that's got to do the time. So
that means that his record will be blemished. But that means that, you know what I'm saying?
But if he's convicted, man, it's over. So.
But you got to convict the person and be. But I mean, and you have to convict them, and it have to be without reasonable doubt, right?
Right. Yeah. But let me tell you, I mean, some people are convicted when that really shouldn't have been. And, juries are very hard to predict. Generally, juries you got to look at them as like a bell curve. 8 to 9 out of 10, 8 to 9. Well, 80% of the time to 90% of the time they get it right. But the other 10 to 20%, they can be unpredictable, and they just get it totally wrong. And it's just so sometimes it's better to make a good deal than go to a trial, even though you got it. But this decision, I don't know that he's going to get to make that decision at this point, because the plea negotiation of a court take a long time and a very complex thing, and you got to do proffers and all this other stuff.
I was just about to ask you that.
Yeah. There's not enough time.
I was just about to ask you that, and because one of the guys whose cases got transferred over to Robert's case because he claiming that Robert told him to do this, all the crazy stuff. At his last status hearing, and the federal government said that they are willing to hold and extend that guy's plea.
Yeah, because he's going to testify.
So that means
he's going to testify.
Right. So that means so in other words, people was like, "Oh no, Don gonna fight this. He ain't gonna testify." And I'm saying to myself, if they doing that,
he's going to testify.
He's testifying.
Yeah, 100%. That's why they're delaying the sentencing. That's why they're delaying the plea.
Right, and then on top of that, but they gave him his trial for January 2022, and I'm saying to myself,
they got to set a date for it's under the speedy trial. So
okay,
they got to set a date, but if they're delaying it like that, he's testifying.
But I'm saying to myself, like, if they merged his charges over to Robert, why is his court date settled far out instead of them putting it all together since they merged his charges over?
Because they just want it, because they want to keep him on the string, so they know they got control over him to testify to what they want to testify to.
I got it. So while he going around YouTube, got everybody thinking that he's for Robert, the whole time, like I said, he's preparing to testify, and as long as he can keep the people from making a noise, that's what it's about.
Yeah, he wants to try to do what's best for him. But look, the bottom line here is that I think that everyone's been exposed for what he is.
Yep.
And what his game is has been exposed. And so and I think what really nails that home is his attack on people who are just trying to do the right thing and be of assistance, and his this vicious attack on these people for no reason, just because they won't let him play superstar. It's just that just shows what he is. So they need to people who support Mr. Kelly, and that's their right to do it. Help. Give Tom and Nicole, your support. Let them know that they got people rooting for them. Because that makes a big difference to them. Believe me, I've been there. So it makes a big difference. When people are supporting you and they don't believe all the horse shit. And let them get through this week so they can put their nose to the grindstone and do as much as humanly possible between now and the start of the trial, so that Mr. Kelly can get a fair trial, and that they can bring all the motions that should have already been brought, do all the things that need to be done, and it'll make a big difference. It really will. It'll make a big difference that they know. It'll energize them. It'll help keep them focused. They won't get discouraged because they've been dragged through the mud. It'll make a big difference, and that's what I hope that now that we've kind of shown what he is, that now people will kind of rally behind the two lawyers who are there just to do their job and do it well.
So let me ask you this: in the post that you put out, right? It was one that you put out last week. Jesus Christ, my mind just went blank. But anyway, for the post that you put out, when Jesus, I hate when that happens, when your mind goes blank.
I know, it's beside the Alzheimer's.
Right? No, no, Joe, I old now. I ain't get no. But yeah.
Well, remember what it was about, or?
Yeah, it was pretty much about Greenberg. Okay, what is his trial record as far as in Fed and state? That's what it was.
His trial record? Well, apparently at some point in time, I heard that he had claimed that Leonard, his partner, has got six acquittals in federal court, and that he's the best in federal court, and that Greenberg's the second best in federal court. Well, when I heard that, I called some friends of mine who really do a lot of federal criminal stuff. Joe Lopez, for one.
Yeah.
Joe.
But I know Joe.
Yeah, Joe did the the family secret's the biggest mob trial in Chicago history. I can tell a reason. So that shows, and I told him that. He was sitting with a bunch of U.S. attorneys, over coffee when I told him that. And I bet you they're still laughing. They all fell over hysterically laughing. And they couldn't, they thought it was the most funniest thing they've ever heard. Look at, I know for the only thing I know that Grimmer's ever been lucky enough to get in federal court that I know of. I mean, he may have gotten, since then he may have gotten acquittal, I don't know. But the only thing I ever knew that he got was a hung jury. Sometimes.
And that's it.
But I mean, he could have got other ones I don't know about that since then. It may have happened. I don't know. But what I think that they're saying, and this is just speculation, what I think they're saying, what I think they're doing is this. If you get, like with Robert, there's like 5 or 6, with Mr. Kelly, 5 or 6 counts, right? Mm-hmm. So you go to trial with 6 counts. And you get not guilty on 3 and guilty on 3. They're considering that to be a not guilty because they got a 3. Their client's going to prison, but there's 3 counts they got not guilty on, and 3 counts, but the other 3 are guilty.
So you didn't win.
Well, I don't. If your client's going to prison, I don't
consider
that to be a win. Yeah, right. I don't consider that a win, right? But so I think that's what they're doing. But they're just hilarious,
So let me ask you this, Joe. Sidebar for a second. Sidebar. If a person is collecting money on behalf of a client, right, and a client didn't authorize it, right, and they collected money from different states, couldn't that person get criminally charged federally if they collected over a certain amount and it didn't go to where it was supposed to go?
It's a serious charge. But yeah, I mean, if you're collecting money for a client without his acknowledge or permission, that's a serious problem. And then if you're doing it on false pretenses, by wire, interstate by wire, that's also a serious charge.
That's what I figured.
Yeah, but I don't know that anything like that's been happening. I mean,
Yeah, it happened.
Well, that's...
You ain't hear from me, but the platform you was on did it 3 times. And I'm going to leave it there.
That's not a good thing, but, look at...
I'm just going to pray for the person, that's all.
Look at it. I don't know. Like I said, I just trying to deal with what's in front of me. But look at, I just wanted, like I said, my goal here was to alert
the masses.
Kelly's, supporters or people who are interested in at least them getting a fair trial, whether they support him or not, that, what games being played here.
Right.
And to try to, help people whose name would got getting dragged through them unnecessarily and unjustly being dragged through the mud.
Right.
To give them a little bit of help, so a benefit of my experience dealing with this character, so that they don't make any of the same mistakes that I may have made. And then and that's it. And I hope the guy gets a fair trial. Just call me. Could you hold on 1 second?
Yeah, go ahead, Joe.
Sure.
Go ahead.
No, just hold on 1 second.
Okay. Hey, we're currently on hold. We're here with the great internet guy, the former prosecutor, the former lawyer, Joe. Just giving y'all a heads up of what's going on. I know some people probably looking at this like, oh my God.
Hello? Yeah.
Yeah.
Unfortunately, this is a call I got to take.
Okay, cool.
But anyway, look, that's all I want to do. I just hope that everybody will, give their support and their love to Nick and Nicole.
Okay.
And just, show them that there's people that believe in them and support them, and don't believe all this garbage that's being said. And I think that, let's hope that they can give them a fair trial.
Right, and anytime you want to come to the platform, Joe, I mean, hey, you here. And you got my number, you got my email, you got everything, man. Just hit me. If you want documents, I'll send them to you.
Well, let's see what happens. I'm really interested to see what happens on Thursday.
Okay.
And, that's going to be interesting. I'll probably talk to everybody. I'll post a few more things over the week, and then on Thursday, let's see what happens.
Okay. And then we'll come back to the drawing board.
Okay, bud. All right, talk to you.
All right, thank you so much, Joe.
Bye.
All right. So, that was a taped conversation with Joel. Great guy. He's talking about his experiences with Greenberg. Hold on. He's talking about his experiences with Greenberg. Steve Greenberg, that is. So, with that being said, like I say, that was Joel Broski, former attorney. He's Drew Peterson's attorney, and Greenberg screwed him over in that case. So I thank y'all for joining me. We'll be back and we'll talk about it more. All right? Those were the questions that nobody asked. Like I say, if you want real interviews, real conversations, real talks, you come here. You don't go nowhere else. Because can't nobody give you what DanaJay can give you. Thank y'all for being supportive. Thank y'all for watching DanaJay. I am the CEO of the Dream Team. And we, meaning the Dream Team and the COO Brooke and all of the other people that's branched out from us, we thank you. Enjoy your Sunday. Be blessed. So with that being said, I want to thank everybody for tuning in with us with the interview.
Babe, I started the car 10 minutes ago.
What? How? I don't need it.
I want to thank everybody for joining in with us. So, y'all heard some great key points. I hope y'all took notes because you're going to need them. The further you follow this case, the deeper it get. Like I said, we getting away from the drama, and we fighting for kills, and we gotta look every which way. We gotta look at every crevice. We gotta look at every which way there is. Me not saying that Greenberg is a dirty player, but hey, that's another lawyer that's coming out talking and providing documentation. You can't argue with that. It's court-appointed, court-stamped documentation. That's crazy. So, I want to thank everybody because we've been here for 2 hours. Y'all be blessed. I'll be back. What time? At 5:10? I'll be back at 7. What's the day? Monday? No, I won't be back at 7. Yeah, I'll be back at 7. Back at 7 for an hour. And then, hey, it is what it is. Keep Robin in prayer. Like I told everybody, because I had some people ask me, Dana, where can I donate? Hold your money for right now. Hold your money. And if you just need to donate it right now, put it in an envelope and put it to the side. If the lawyers come out with something else, because you know that, things happen. But if the lawyers come out and with something else, I'll be the first to let y'all know. So, hey, until then, let's fight to get Doug back up on the main case. And let's pray for Nicole and Tom to do what they do. All right? Y'all be blessed. Love every last one of y'all. DanaJay up out of here. Until next time. Shout out to Oko for stopping through. Grown little boy. About to be away from us for a minute, but hey. Take it like a champ, bro. We all gonna be praying for you. All right, peace.
Say you love it, what you gonna do now? Hope you're ready, 'cause I'm really about to